Hello, this is Linda Amato from Amato Law. My firm is located in New York City. We are solely devoted to the practice of estate planning and elder law. We are creating a series of videos to help you and your loved ones understand the importance of creating and having an estate plan. This question comes up often. People don't understand. They've heard a lot about trust planning, and they want to understand the difference between if they decided to create an estate plan and create a revocable trust rather than relying on a traditional will. Well, the main difference between a will and a trust is that a will is subject to probate. Now, every state has their own probate rules. In New York, our probate process can be quite involved depending on the complexity of the estate and whether or not the heirs at law are persons that can be easily identified. As I said, a will has to go through the court system. So it has to have the oversight of the court, and the court has to determine that the will was executed properly. If it's not executed properly, then it's considered void, and it doesn't matter what the terms of the will are. The assets in the estate will purely be distributed in accordance with the intestacy laws of New York State and divided according to that formula. As far as planning with a revocable trust, we don't really rely on probate because the assets in the trust are retitled, in your estate are retitled to your trust during your lifetime. So there's no reason to go to court because there's no reason to get a legal title to those assets because they're already owned by your trust, and your successor trustee can distribute those assets immediately without waiting for the court to give the approval. It's private, it's organized, and it keeps things moving a lot quicker because you're not working with under the supervision of the court, which can be at times imposing the requirements of different documents that are needed in order to get that petition approved, and so that letters testamentary can be issued to the executor. With trust planning, we also have the opportunity to do a lot of extensive planning for your beneficiaries. You may have a child or a grandchild or a beneficiary that has special needs. You can create a special needs trust for your beneficiary with those special needs so that their inheritance doesn't interfere with maybe their disability benefits. That is considered a third-party trust, and it's a tremendous planning tool for anybody that has a beneficiary that is on disability. With a revocable living trust, we're also doing tax planning if it's needed. We're also making some contingency planning in terms of what happens when a beneficiary may be in a situation where there's creditor problems. If you're concerned about money going to a beneficiary that has a history of lawsuits or bankruptcy, you don't want outright distribution of cash. You would want their inheritance to be insulated from creditors, and there you can do that in trust planning. You also can protect assets for your beneficiaries in the event of a divorce, so that the money is kept, the inheritance is kept in the bloodline. So a lot of creative things that you can do in trust planning that are quite attractive for people today because they really are looking to make things very organized for their families, and they really are not interested in going through the petition process with the court system. And so it is a good option, and also a revocable trust is a backup device that helps with incapacity planning, because a will is really just a document that's going to become active upon your passing, and it's going to be distributing your assets and according to your wishes, but it really is not going to offer you any type of support if you have an episode of disability during your lifetime, where a revocable trust can act as a backup device because your assets are owned by the trust and you've already designated a successor trustee. So there is no reason to petition a court for a guardianship if you become disabled, because your successor will have the legal authority to take over all the authority that you had while you were acting as a trustee of your trust. So it is an interesting, and I think that during the pandemic, we really saw a lot of people becoming much more interested in exploring revocable trust, because we did see what happened with the courts being closed for several months, that people that were passing that had wills, their wills could not be probated. And so it was a financial burden because the assets were frozen in the estate. Compared to those clients that had a revocable trust, we didn't really care about what was happening in probate because we didn't really need the court intervention. So I think moving forward, the revocable trust is going to be considered a very interesting and advantageous option for certain types of clients that you may want to think about. Thank you.